Hi, in this video, our group composed of Gauri, Chahat, Nigar, Tanim, Tasnova, and me, Apurv, will be talking about the different types of discriminations in the workplace and how they should be dealt with legally. This video is a final group assignment for the Legal Risk in Business course, which is part of our Masters of Management program. We chose discrimination in workplace as a topic for the presentation as we personally feel that when students start as freshers in the corporate environment, it is very important for them to be aware and to be prepared for any kind of discrimination they might face in the near future. So let's start with understanding what is discrimination in a workplace. Discrimination in the workplace occurs when an individual or group are treated unfairly or unequally based on certain characteristics, such as including religion, ethnicity, sex, age, family status, and sexual orientation. Scenarios for workplace discrimination vary greatly and may include situations where individuals are denied the opportunity for employment or promotions, denied equal pay or equal work, denied entitlements such as overtime pay, or are harassed based on certain characteristics. Now let's discuss six types of discriminations that an individual can face in the workplace. The first type of discrimination is race discrimination or racial discrimination. Racial discrimination is a discrimination done against any individual based on skin color or ethnicity. It is one of the most common types of discriminations that happens in the workplace. Let's look at some examples. A candidate not getting hired by an organization because of being Aboriginal, even after being the most suitable candidate for the job. Or a British employee not given a project in India because of the assumption that the client in India will not like them, which might impact the organization's business. Now let's talk about the second type of discrimination in the workplace, which is disability discrimination. Now, disability discrimination occurs when an individual is put at a disadvantage for a reason that relates to their disability. Let's take a direct example of it, which is very much more obvious. During an interview, a job applicant tells the potential employer that he has multiple sclerosis. The employer decides not to appoint him, even though he's the best candidate they have interviewed, because they assume he will need a lot of time for being sick. Now let's look at another example, which is not very obvious and is indirect in its effect. A job ad states that all applicants must have a driving license. This puts some disabled people at a disadvantage because they may now not have a license because, for example, they have epilepsy. The requirement will be justified if the ad is for a bus driver job, but not in the case when we are talking about a teacher's position where she has to shuffle just between two schools. Now let's talk about the third type of discrimination, which is pregnancy discrimination. Now, pregnancy discrimination is a kind of discrimination which is against expecting or new mothers. Let's look at some examples of pregnancy discrimination in the workplace. Employers making excuses to discipline or terminate employees when they learn they are pregnant. Employers also eliminate positions while a pregnant employee is on leave or deny them leave in the first place. Another example can be as simple as firing a pregnant woman or not hiring them in the first place. Now let's talk about our fourth category, which is gender discrimination. Now, workplace gender discrimination comes in many different forms, but generally, it means that an employee or a job applicant is treated differently or less favorably because of their sex or gender identity. Now, for example, a candidate not being hired or being given a lower paying position because of their gender identity. Another example is being subject to unwelcoming sexual advances, requests for sexual favors, or other verbal or physical harassments of a sexual nature. So these both examples cover different aspects of gender discrimination. Now let's talk about the fifth and the last type of discrimination, which is age discrimination, or in short, ageism. Ageism simply means prejudice or discrimination based on an individual's age. Let's look at some examples of ageism manifesting in the workplace. Someone might experience age discrimination when an employer refuses to hire them because of their age, or they might be fired because of their age. Another example would be the learning opportunities are automatically offered to the younger employees, not the older ones. This can include the educational coursework, access to reimbursements for continuing education, and access to professional or the industry conferences. With this, I would like to hand on the baton to my dear friends Tanim and Nigar, which are my classmates too, and I would request them to continue the presentation further.
Thanks, Apurv. Hello, everyone. I hope everyone is doing well. Based on the different workplace discriminations, now we will look at the different types of cases similar to the kinds of workplace harassment we discussed in our previous section. And we'll be starting with the racial discrimination by the federal government of Canada. We all know that Canada is one of the most diverse countries in the world, yet there is a presence of racial discrimination in the federal government offices as well. Last year, Radio Canada published a report where they found a black man who had paid by the government officials to stay quiet about the racial discrimination and was also threatened to lose his job if not obeyed. The report says that almost 800 black people filed a case against white people for racial discrimination. Dog Hill, a grievance and adjunction officer for the Public Service Alliance of Canada in Halifax, said about 70% of the complaints he handles are resolved through settlements that contain similar confidentiality clause. He also said that compensation offered sometimes goes well beyond the maximum $40,000 can be paid under the Canadian Human Rights Act. There is no maximum amount when it comes to federal government, which is here in this case. But critics say these arrangements are problematic because they cover up the real problem instead of addressing it. By making the problem invisible, we are making the victim invisible. And we basically have no precedent to build on and no lessons to learn. Often people don't realize the implications of signing an agreement that includes a confidentiality clause. Now we'll be talking about the disability discrimination in workplace. We will be talking about the case of Hagi, who was originally hired in 2015 as an operations consultant, but within the first few weeks of her employment, she increasingly took on roles in the dispatch department. She testified that she was soon doing the work of several full-time positions as numerous dispatchers either left or were fired by the company. While still attempting to fulfill her consulting duties from home, in the summer of 2016, Hagi suffered from an acute angina attack and was taken to hospital where she was diagnosed with ischemic heart attack. Her condition required major surgery on her heart as well, left her drained of stamina and need to inhale nitro several times a day to treat symptoms. She was advised to avoid stress. Then she suffered a second cardiac event at work shortly before her medical leave, again needing to be taken to hospital. When she returned to work after 4 months of medical leave, she saw the replacement was sitting at her desk. Hagi was moved to another desk with no phone and no internet to computer system. She was waiting with no work. Later that day, she was fired by the company's owner. The tribunal did not find the owner's testimony convincing. Haki described the firing as one of the most difficult experiences in her life and fought back tears during her testimony, having to take several breaks to compose herself. Hence, the company had to pay 12,000 Canadian dollars as damages for pain and suffering caused by the company. The next case is based on pregnancy discrimination, where Yvette Ratton was fired because of her pregnancy. She worked at Topper's Pizza in the community for 18 months. She started as a delivery driver and then promoted to kitchen supervisor. After a few months, the manager asked her about a rumor that whether she was pregnant or if it was heresy. Ratton told him the truth that it was true, but she didn't want to say anything until she was past the safety net and first trimester because she was in high risk and she had lost a few before. After that, she had been terminated, and after 10 days of her termination, Ratton was sent to hospital. The pregnancy was ectopic and where the fetus develops outside the uterus, and she miscarried. She filed a case, and her doctor testified that the main reason she was depressed was not that she had a miscarriage, but because she was terminated from her employment, which she dearly loved. A decision handed down last week awarded Ratton 20,000 Canadian dollars for injuries to her dignity, feelings, and self-respect. Statistics obtained from the Human Rights Tribunal of Ontario showing that 810 companies were filed on the grounds of sex, pregnancy, and gender identity. Moving forward to the next one, which is more common in Asian countries but not very rare in Canadian countries as well, and that is gender discrimination and marital status. Losley worked for the company as an account manager from 2009 to 2017 and was around 50 and unmarried during that time. Miss Lousy experienced five unwanted physical contacts when the proper amount of physical contact of this nature in the workplace is none. Losley's allegation ranged from the aforementioned physical contact to being given the middle finger by a colleague and her ideas being discredited in the meetings after her marriage. Miss Losley's negative experiences at Windward Software Incorporation did profoundly impact her life, and she still has significant difficulty and emotions related to the same. Windward's testimony was not convincing to the judge, and judge gave the decision towards Losley. The company had to pay 15,000 Canadian dollars to the women for compensation of the mental instability caused. However, Losley claims that she filed the case to warn all the employees like this and save other women to face the same situation in near future. Thank you everyone. Here are the references I have used for the analysis from my part. Now moving to Niger for more cases like this.
Hello everyone, now I am discussing the age discrimination case. IBM is being sued by hundreds of the workers for age discrimination. A case was filed against company accusing age discrimination, where company executive discussed in email how to force out older workers. The executive referred to the old employees as dino babies who should be made an extinct species. The external communication was highly incriminate enemies against older employees. Officials complained how millennials are being preferred by the IBM compared to the competitor. They are firing thousands of employers who are older to make room for the millennials. The report also alleged that the company pushed older workers into resignations or the retirement, and then they hired the same person as a contractor or contractual worker with less pay and less benefits. More than 18,000 age discrimination cases were filed in US against IBM in 2017 alone. Now I am discussing a case where women were suffered rampant sexual harassment. A Tesla employee has filed a lawsuit against the company for rampant sexual harassment. The employee narrated in her lawsuit her experience of sexual harassment from colleagues, including alleged cases of catcalling and inappropriate touching. According to the worker, her colleague would describe her for having Coke bottle figure and onion booty, among other disrespectful disrespectful description. She also stated that she experienced such harassment for almost 3 years, which robbed her sense of security. She complained the harassment to the HR and nothing has taken by the HR. According to the post, she was on medical leave and diagnosed for the post-traumatic stress disorder. Here is the another case where husband and wife both are discriminated in the workplace by the employers. Hayne and Jane worked as a travel tapper in Calgary. In October 2008, they both are hired by the Summit Travel contractor. On December 3, 2008, Jane injured her back lifting a pail of mud. On December 11, Hayne told Summit owners that her injury was more serious than they expected. She had complex regional pain syndrome and pain in her both upper and lower back. But they didn't file any worker compensation claim as they worried that Haynes would be fired as they knew of some of the subcontractors were lost their job after getting hurt and filing a complaint. Yet later they filed a compensation claim, also asked for accommodation for John. But the company rejected for the accommodation and fired Haynes for the marital relationship with Jane. And Hayne and Jane each filed a human rights complaints. Jane for the discrimination in the employment on the basis of physical disability and Hayne for the discrimination on the basis of marital status. Here is the case where man was suffered for religious discrimination in his workplace. Edward Hedican was offered the position of assistant manager at Walmart, who is the Seventh-day Adventist. Due to his religious beliefs, he needs some special accommodation for Sabbath. HR tried to accommodate but concluded that his religious belief cannot be considerable. On the other hand, HR offered him to apply for a lower position for the accommodation. However, Hedicat was not satisfied with that and Hedicat filed a case against Walmart for not accommodating his religious belief. After that, Walmart's testimony was not convinced to the judge and hence they had to pay a large sum of money as compensation. That's all my part. Here is some reference that I have used to make this report.
All Canadians have the right to equality and equal opportunity, fair treatment, and an environment free of discrimination on the basis of sex, sexual orientation, gender identity or expression, marital status, family status. It protects Canadians from discrimination when they are employed by or receive services from the federal government, the First Nation government, or private companies that are regulated by federal government like banks, trucking companies, broadcasters, and telecommunication companies. The Section 7 of Canadian Human Rights Act states that it is a discriminatory practice to directly or indirectly to refuse to employ or continue to employ an individual or in the course of employment to differentiate adversely in relation to an employee on a prohibited ground of discrimination. According to Section 11, subsection 1, it is a discriminatory practice for an employer to establish or to maintain difference in wages between male and female employees employed in the same establishment who are performing work for equal value. Wages here means any form of remuneration payable for work performed by an individual, and it includes salaries, commission, vacation pay, bonuses, payments in any kind, employer contribution to pension funds or plans, long-term disability plans, and all forms of health insurance plans, and any other advantage received directly or indirectly from the individual's employer. The subsection 3 states that separate establishments established or maintained by an employer solely or principally for the purpose of establishing or maintaining difference in wages between male and female employees shall be deemed to be the same establishment. There are several policies in Canada in order to avoid pregnancy discrimination in workplace. The Ontario Human Rights Code is a law that provides equal rights and opportunities and recognizes the dignity and worth of every person in Canada. The code makes it against the law to discriminate against someone or to harass them because of sex, which includes pregnancy and breastfeeding in employment, trade, or professional association. Pregnant women have significant legislated rights in addition to those under the code, most importantly under the Ontario Employment Service Standards Act. Under Section 23, subsection 2 of the Code, employers cannot make enquiries, whether written or oral, during the application stage of the hiring process that directly or indirectly classify applicants based on a prohibited ground. Employers cannot request that applicants provide information about whether they are, have been, or intend to become pregnant, even where an employer still offers the women the job. These types of questions are considered to be discriminatory. According to a report published by the Globe and Mail, on paper, workplace discrimination is illegal, and there are decades old laws against paying women and men in the same job different wages because of their gender, against firing someone for becoming pregnant, against demoting a person for taking maternal leave, against sexual harassment in workplace. While Canada has all these laws it needs to prevent gender discrimination at workplace, they are almost never enforced.
Hello, this is Tasnuva. Thank you, Gauri, for discussing the two most important laws of Canada. Now I would like to discuss about Section 15. The Charter of Rights and Freedom of Rights protects basically the rights and freedoms that are essential to keeping Canada a free and democratic society. It is a powerful force for progress, protection, and fairness with the power to influence our society by interpreting laws and policies. The equality right ensures equal treatment, equal opportunity, and equal protection. The Section 15 also recognizes the right to be free from discrimination. Discrimination occurs when an individual or a group suffers a distinction, whether intention or not, based on a personal, unchangeable characteristics, the purpose or effect of which denies a benefit or puts a burden on such individual or group. So basically the main federal laws which protect people with disabilities from discrimination includes the Canadian Charter of Rights and Freedoms and the Canadian Human Rights Act. It is under the Section 15. So what basically the 15.1 states, every individual is equal before and under the law and has the right to the equal protection and equal benefits of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Who does the Charter protect and what rights are protected? Any person in Canada, whether they are a Canadian citizen or permanent resident or a newcomer, has the right and freedom contained in the Charter. The rights under Section 15 includes racial equality, sexual equality, mental disability, and physical disability. All Canadians will be treated with equal respect, with equal equality. This enables fair treatment for all and avoids sufferings. All Canadians will be safeguarded under the same set of laws without any discrimination, as ensures security of all people, avoid riots and violence among people, and promotes greater sense of peace in society. Section 15.2 basically aims at enabling government actions intended to combat discrimination proactively through affirmative measures. So what basically 15.2 is states that Canadians are free to follow the religion of their choice. In addition, they are guaranteed freedom of thoughts, beliefs, and expression. Since the media are an important means for communicating thoughts and ideas, the Charter protects the rights of the press and other media to speak out. The government can use 15.2 as a defense when an individual or group can show that a government program treats them differently based on their personal characteristics. The equality rights under Section 15 also signifies that this law ensures all Canadians will have the same facilities available to them without any discrimination, as it allows equal progression in society, prevents feelings of envy or jealousy, and ensures global satisfaction overall. This law means that the government must not discriminate on any of these grounds or on its laws or programs. The court have held that Section 15 also protects equality on basis of other characteristics that are not specifically set out in it. For example, the section has held to prohibit discrimination on the grounds of sexual orientation, marital status, or citizenship. The Supremacy Court of Canada has stated that the purpose of Section 50 is to protect those people who suffer social, political, and legal disadvantage in the society. At the same time as it protects equality, the Charter also allows for certain laws or programs that aims to improve the condition for disadvantaged individuals or groups. The freedom of religion under law section 2 states that the right to entertain such religious beliefs as a person chooses, the right to declare religious belief openly and without fear of hindrance or reprisal, and the right to manifest religious beliefs by worship and practice or by teaching and dissemination. The discrimination because of religion is against the law in Canada. Every person has the right to observe his or her religion unless it interferes with others' right or health concern. Freedom of religion in Canada is protected by the Canadian Charter of Human Rights and Freedom and Canadian Human Rights Acts. The government laws cannot restrict religion freedom unless they infringe on other rights and values in Canada, for example, the right to equality. If someone experiences religious discrimination, they should contact the Human Rights Legal Support Center for free legal support among such situations. So these freedoms are set out in the Charter to ensure that Canadians are free to create and express their ideas, gather to discuss them, and communicate them widely to other people. These activities are basic form of individual liberty. They are also important to the success of a democratic society like Canada. In a democracy, people must be free to discuss matters of public policies, criticize government, and also important, have their own solution to social problems. Everyone has the following fundamental freedom under the Section 15. Where can the religious rights be protected in? The Supreme Court has recognized religious freedom as important for self-fulfillment, participation in social and political decision-making, and free exchange of ideas. The equality right is important as it provides equal independence to allow for a more peaceful, happier society and successful coexistence in the society. Why this law is so important? Freedom of religion helps to ensure that religious minorities are not the subject of discrimination. It is crucial to maintain a private sphere for individuals and communities where the government does not and cannot intrude. The state should be neutral and impartial when it comes to matter to deeply held personal beliefs. Thank you, everyone.
When it comes to dealing with various types of discriminations, be it at workplace or at daily life, we generally choose either of two choices, whether we start looking for another job or we keep it facing due to the fear of losing job, workplace friends, or the comfort level they have at the present job in terms of work. For many people that experience a type of discrimination in the workplace, dealing with it can be difficult and confusing. You may worry about putting your job at risk, or you might even worry about your work relationships. These are valid concerns. Discrimination in work can take many forms. It can be direct, that is, where you are treated differently in the workplace because of personal characteristics and you may suffer harm. Racial slurs or jokes. An employer doesn't hire a person for a job because they are transgender. Co-workers harass a worker over their race, religion, sex, or other protected characteristics. An employer fires a worker because she is pregnant. Experiencing discriminations at work have severe impacts on your performance as employee as well. Some of the effects of it includes fear, depression, and anxiety. Let's now discuss several ways to tackle discriminations and ways to stand legally correct. So, talking about some of the ways to tackle discriminations, there are some steps which we can take to deal with the discrimination. If you are disadvantaged at work because of personal characteristics, your employer has a duty to accommodate you. You can ask your employer to help you in this and investigate the problem. The Occupational Health and Safety Act says that employer must do this if someone tells them about possible discrimination or harassment at work. Your employer must also give you a written report of what they find, and they must tell you what steps they are taking to deal with the problem. Focusing on your strengths and core values, beliefs, and perceived strengths can motivate people to succeed and may even buffer the negative effect of bias. Overcoming hardships can also make people more resilient and better able to face future challenges. One problem with discrimination is that people can internalize others' negative beliefs even when they are false. You may start to believe you are not good enough, but family and friends can remind you of your worth and help you reframe your faulty beliefs. Getting involved with like minded people and organizations can help you to know that there are other people who have had similar experiences to yours, and connecting with those people might help you figure out how to address these situations and respond to experiences of discriminations in future. Don't dwell. When you have experienced discriminations, it's hard to let it go. People often get stuck on episodes of discriminations, in part because they are not sure how to handle those experiences. You might want to speak out or complain, but you are not sure how to go about it or are afraid of those backlashes. So instead, you end up ruminating or thinking over and over about what you should have done, but it can cause stress and anxiety. In a calmer moment, it might be helpful to talk over the ways you can cope with similar experiencing in the future. Try to come up with a plan for how you might respond or what you can do differently next time. Once you have determined how to respond, try to leave the incident behind you as you go on with your day. Seek professional help. Discrimination is difficult to deal with it and is often associated with symptoms of depression. Psychologists are experts in helping people manage symptoms of stress and depression and can help you find healthy ways to cope with that. While facing discrimination, we either quit the job or continue working under toxic environment. Mostly companies who fails to address the concern of an employee regarding discrimination will create a surroundings based on a forced resignation or constructive dismissal, which occurs when you leave your job because you are put under a pressure to resign or your employer says that you must quit. You may want to vacate your job, but you are told you must retire, or you feel you have no other choice but to walk away. But on the other hand, when you are fired, the rules set by provincial and common laws require that your employers pay a severance package, which could be as much as 24 months' pay, depending on certain factors, as compensation. If you resign, you can't claim anything, and you may also not be entitled to employment insurance. Generally, companies choose this way to avoid paying severance package. Still, if the workplace becomes hostile or toxic due to ongoing harassment or discrimination, and the company fails to take steps to eliminate the problem, you may have no choice but to quit. This can also trigger a constructive dismissal claim, and you may be entitled to human rights damages in addition to severance. If your employer is trying to force a resignation, make sure you document their attempts in writing. You need to have proof that your employer is trying to force you quit. Emails between you and your employer in which both your positions are made clear are solid piece of evidence. Considering if someone wants to take an action against an employer using legal help, there are some options available. First, you can make a human rights complaint. If the council decides your complaint is justified, It can order the employer or other person to stop discriminating against you. It can order that you get your job back or be given the right to compete for a job. The council can also award you money for lost income and for injury to your dignity, self-respect and feelings. Second, if your employer didn't follow the Employment Standards Act, and you can make an employment standards complaint. However, if you go by this route, you will only be able to claim whatever severance pay your employer owes you. You won't be able to get compensation for discrimination, and if you choose this option, you could be barred from starting a human rights complaint. Third option you have, if you lose your job because of discrimination, you may decide to sue for wrongful dismissal. But the court can only award you damages for your lost wages. It can't award extra damages to compensate you for the discrimination. You are likely to collect more if you file a human rights complaint because you can get damages for lost wages as well as discrimination. In case of union, if you belong to a union, one option is to ask the union to file a grievance about the discrimination. If your union refuses to file a grievance on your behalf, you may be able to file a complaint against your union for failing to represent you fairly. These were some of the points based on internet research, published articles, as well as from various law firms' website. We would highly recommend seeking a legal help if anyone is facing or have faced any discrimination at work or in normal life. Thanks for watching our video presentation. And here are some of the references which we have used to make our video presentation. We hope you like our video. Thanks for watching.